Today, I'm going to cover very briefly a few reasons why you shouldn't die without a will. If you die without a will, it's called dying intestate. If you die intestate, then you don't get a say over what happens with your estate assets when you pass away. In Queensland, there are certain default or automatic rules which apply if you die without a will. Here's a brief summary diagram of what happens in Queensland. As shown here, your estate assets will go to your spouse and issue, being your biological children or grandchildren and so on. In the absence of a spouse or issue, it will pass on to parents and so on through the outer rings of the diagram. Ultimately, if you have no living relatives in the hierarchy, it may pass to the Crown or the government. So here are a few reasons you shouldn't die without a will. No executor. Without a will, you won't have an executor who can take care of the process and paperwork of administering your estate. Instead, a person or persons will need to apply to the court to be the administrator of your estate. Once again, there is a default hierarchy as to who the administrator would be, and if a person lower on the hierarchy wants to be the administrator, they would have to give reasons why it shouldn't be a person higher on the hierarchy. You have no say. When you don't have a will, you don't have a say on who receives your assets. So if you don't want your assets to just pass in accordance with the intestacy rules, as shown in that diagram, it's best to make a will and actually say who you want to receive your assets. For example, if you don't have a spouse or children and you'd prefer your estate assets go to your brother or sister rather than your parents, you would need to make a will to specify this. Increased stress for your loved ones. When someone you love passes away, it's already an incredibly stressful time. By not having a will, it can really amplify this stress for your family and loved ones. If you have a valid legal will in place, the process can run much more smoothly, and that's one less thing for your family to worry about at the time. Leaving your children without a guardian. If you have children, or perhaps are planning to have them, you can appoint a legal guardian via your will. Naturally, there are other processes for guardianship of your children if you fail to appoint a guardian via your will. However, exercising a conscious choice in choosing and appointing a guardian certainly seems the best course of action, and certainly the more thoughtful course of action as a parent. More costly administration costs. Having a will in place can reduce the costs of administration of your estate, as in most cases an executor will be appointed who can begin to act immediately. This way you don't have to apply to the court to appoint an administrator, and the distribution is set out in the terms of the will. Unless the will is challenged, the distribution, who gets what, is generally followed. Getting your estate planning sorted ahead of time avoids unnecessary pressure on your loved ones at an already difficult time. Thank you so much for your time. I really appreciate it. And if you have any questions, feel free to email me or contact me on one of the social channels or leave a comment below. Cheers, Vox out.